Bedbug litigation is an up-and-coming area of the law. There are certain things, if you are a victim of a bedbug infestation, or even if you are an apartment complex or hotel operator, that you should know about bedbug liability. This segment of our website is designed to help people navigate through all the different issues involved with bedbug litigation. Here's a brief overview. One of the first things that landlords and hotel operators are responsible for is to inspect. They need to inspect for bed bugs. They need to establish protocols for bed bug remediation and inspection. They need to warn guests of bed bugs if there are bed bugs on the premises or have had bed bugs on the premises. And in the case of apartment complexes, landlords even may have the duty to evict a tenant who interferes with inspections or bed bug remediation. Also, it's on the landlord to help tenants who are mobility impaired to assist them so that bed bug treatment can occur and the inspections can occur as well. There are basically three different ways that a hotel or an apartment complex can get sued for bed bugs. The first one is premises liability. That is very similar to your slip and fall cases. It's very similar to people that fall down the stairs or fall into a sinkhole in the yard or a crack in a sidewalk. It's the same cause of action that we see in bedbug litigation. There are factors that the court will use to assess whether or not a premises owner has liability. The main one is factor that they're going to look at is the reasonableness of the inspection, repair, and warning. Those are the main factors that are going to be looked at to establish liability in a premises liability case. If the landlord or the hotel operator did not do an adequate inspection, if they did not warn their guests of the perils, or they did not repair or remedy the situation, they could be found liable. Under a premises liability or negligence case, damages can also include bodily injury, they can include emotional distress, and they can include damages that are profound and basically up to a jury or a finder of fact, a judge, to make that determination. The second cause of action that we see in bedbug litigation is the warranty of habitability. If you have a lease, there is an express warranty of habitability, which is a written warranty of habitability that is normally found in a lease. If you have government assistance and you have a HUD lease, the HUD leases have express warranty of habitabilities written right into there. If you have a general lease on a bar form or the standard leases, those have habitability representations that are written into the contract. But even if the lease, or even if you don't have a lease, if there's nothing specific that gives you a warranty of habitability, there's what's called the implied warranty of habitability. And the implied warranty habitability is a warranty implied by law that by leasing a residential property, the lessor is promising that it is suitable to be lived in and will remain so for the duration of the lease. Now the question is, when does liability arise? Now it's important to understand that just the mere fact that bed bugs exist on the premises does not give rise to liability to a landlord or hotel operator. A landlord is only liable for injuries resulting from hidden or latent defects if the landlord knew or should have known of the defect, which means they either knew or should have known about the bed bugs. Implicit in the standard is the rule that a landlord must, on some occasions, make reasonable inspections to search for the defects, which means the landlord has an obligation to search for the bed bugs. And where there is a potential serious danger, which is foreseeable, a landlord should anticipate the danger and conduct a reasonable inspection before passing possession to a tenant. That's also the same standard that a hotel operator has. So hotel operators should be, every time that they change a room, they should be inspecting for bed bugs. Every time an apartment complex flips a unit, they should be inspecting for bed bugs. The third cause of action that is uncommon, but if a plaintiff's lawyer should always be looking for, is whether or not an infestation is actionable under their unfair deceptive acts and practices, which we call UDAP, which is a private right of action for consumer fraud. And the thing about consumer fraud that's different from premises liability and is different than the warranty of habitability is that there is no personal injury that's recoverable under the UDAP statute. Under the consumer fraud or UDAP statute, what you're looking for is an ascertainable loss. And if there's an ascertainable loss, what the damages would be a rebate in rent. Also, those losses, if it's willful and wanton in the state of Iowa, you can get actual plus treble damages or triple damages. So you add those together and you could actually get 4 times your ascertainable losses. That is important because when you're talking about rebate and rent, if you're paying $500 a month and you had 1 month worth of infestation, the rebate could potentially be $500 for that 1 month times 4 to $2,000. So potentially for a $500 a month unit, you could be compensated on the rebate and rent $2,000 a month plus your loss in property and any other ascertainable loss that is due and owing to you. The other thing that you are entitled to if you successfully prove consumer fraud is you're entitled to reasonable attorney fees. There is a fee shifting statute which, in addition to your damages, you are entitled to the defense or the landlord or the hotel operator paying for your attorney fees. What's also important under the UDAP statute and the protection under the UDAP statute is that there are certain times that landlords will either refuse to repair the bed bugs, or they could be abusive and threatening to the tenant. That in and of itself is a violation of the consumer fraud statute. And what does it mean to be abusive or threatening? Does it mean that the landlord actually has to wave their fist at you? The answer is no, that's not the case. Conduct which is reasonably anticipated to deter a tenant from complaining about bed bugs would be considered abusive and threatening and is actionable under the UDAP statute. We want people to report and freely report bed bugs. From the standpoint of an apartment owner, from the standpoint of a hotel operator, the cheapest, most inexpensive point in time that they have to deal with a bed bug introduction to keep it from an infestation is the day they learn about the bed bugs. That is going to be the moment in time that they could remedy the situation at the lowest cost to them. And so conduct that deters people from reporting is a UDAP violation. The measure of damages, in addition to those attorney fees that we talked about, is the difference between the fair market value of the property in its warranted condition and its actual fair rental value. So, if I were to tell you that I have an apartment that's usually rented for $500 a month and it has bed bugs in it, how much would that be worth to you? Most people would say zero. So basically the measure of damages is the value of the apartment in its warranted condition, which is $500 a month, less what its condition is in its actual condition, which is zero. So the measure of damages is $500. Again, for willful and wanton conduct, that would potentially be $2,000 a month, plus the attorney fees and the property loss. Now, it's important when you're dealing with bed bugs that you also get a very good pest control operator. Not every pest control operator out there is qualified to do bed bug remediation. It is important to do your homework. If a bed bug operator says they only have one way that they recommend to ever treat bed bugs, they probably only have one thing in their toolbox to treat bed bugs with. You want a pest control professional, a pest management professional, an exterminator that has adequate tools in their toolbox to do the job, which means they should have adequate chemical remediation abilities. A lot will have heat remediation in certain parts of this country, fumigation. Some people have steam. There's a lot of different techniques that are used to treat bed bugs. You need to make sure that your pest control professional has the tools in the toolbox to get the job done. You should be asking for references and make sure that they have the experience and the training to do bed bug remediation. Thank you very much.